Hello, everyone. I'm Jim Boatman with Boatman Ritchie Law Firm, and been trying to provide some information about a really significant issue right now. It's always been significant, but it's really coming to a head now, and that is the issue of both religious and medical exemptions in relation to the shot or the vaccination, as many are calling it. I'm here with Ben Yormak. He's just an excellent labor lawyer that I've known for a long time. The name of his firm is Yormak Employment and Disability Law. I mean, he's your guy. He's board certified, handles all kinds of really critical matters, and just known him for many, many years. And in many respects, and I think most of the respects that matter this day and age, Ben and I are kind of cut from the same cloth. So we wanted just to have a conversation. I've had a previous conversation earlier this week with another lawyer about what we can do pre-litigation in order to put someone in the best possible position to assert an exemption and then be able to sustain it if it comes under scrutiny, judicial scrutiny. And Ben is on the litigation side. He obviously handles pre-litigation matters, but he's a litigator. And so we wanted to have a conversation. So good morning, Ben. Thanks for joining us.
All right. Thanks for having me, Jim. Good morning.
So why don't you sort of give your overlay? You've seen some of the information that's out there vis-a-vis efforts to articulate religious and medical exemptions. And why don't let's just kind of double click on those topics and share with us some of your thoughts and considerations for people to keep in mind if they're going to go down this path.
Absolutely. And first thing I want to point out is that using the term religious exemption or medical exemption is a bit of a misnomer. You're not necessarily exempt just because you either have a disability that precludes the vaccine or a sincerely held religious belief. It's much more nuanced and involved. And quite frankly, if not done right at the front end, you have no case at the back end. And as you pointed out, we handle things right from the pre-litigation moment when the employer says you got to get vaccinated, all the way straight through to trial. The majority of these cases do end up in federal court. And so federal courts in Florida are not necessarily bound by those in other states, but the analysis that comes from other states is looked to for some guidance. On the administrative side, the Federal Equal Employment Opportunity Commission, the EEOC, gives guidance to employers and employees on what is reasonable and what is not as far as requiring vaccinations. And the current state of the law is, by and large, mandatory vaccinations are enforceable to the average Joe or Jane. The real question comes with what happens when somebody's doctor, for example, says, I wouldn't advise this. This is just not good. Give you a prime example. We had a wonderful, nice lady call us almost in tears, 20-year employee of a large pharmaceutical company. She's immunocompromised. And her doctor had said, absolutely, don't do this vaccine, bad idea. If you get an adverse reaction, it could be really bad. Takes this to the employer, and the employer turned around and said, nah, you got to get it anyway. And she said, are you kidding? I have been a remote employee for years. I haven't set foot in an office for years. Why am I not being granted this? And we're seeing a lot of that. We are seeing tons of that kind of overreach where the employer is basically sitting on high and saying, thou shalt get vaccinated. And it doesn't have that right.
Yeah. Well, did you happen to see, I don't know if you've seen the Project Veritas piece. Let me just show this really quickly, just because this just came out last night. And it just blew me away. I just took a little excerpt of it.
first dose of vaccine after surviving this entire pandemic.
She didn't want to take it. She didn't want to take it because of her religious beliefs. And she was coerced into taking it. And it's like, nobody should have to decide between their livelihood, being a part of the team in the hospital, or take the vaccine. Now we're just making people take it, and then there's reactions to it, and then you have a medication that has been shown effective and surely has no adverse reactions for trying it.
So, I mean, that's exactly what we're talking about, and it's happening everywhere. So what happened in your situation?
So that situation still remains ongoing, but let me just be clear for your viewers as to what's exactly required. Okay, this is a two-step inquiry. And as I said at the outset, calling it an exemption is, I think, putting an idea in people's heads that if they have a medical or religious reason, they just don't have to get the vaccine and they can tell the employer to, go take a hike. And that's not what the law says. If you have a medical or religious reason to not get vaccinated, you graduate to step 2 of the analysis. And the analysis from religion and medical at that point merge and becomes identical. The test is whether or not there is a reasonable accommodation that would allow the worker to perform the essential functions of their job. That can be a number of different ways. Okay, it's not limited. That requires that the employee and the employer sit down and engage in a discussion, which is called the interactive process, to figure out a reasonable accommodation that is short of getting vaccinated. So to give you an example of kind of what this might look like, if an employee is able to perform all of their essential job functions remotely, that should probably be granted by the employer. If the employee has to come in to the office, for example, it might be that they have to wear an N95 mask the whole time. It might be that they have to agree to daily COVID testing. Again, we have to go back to what the intent of these really are. The rule of mandatory vaccination is ostensibly geared towards workplace and customer, client, patient safety. That's at least what the face of it represents. But if you can accomplish exactly those goals without a vaccination, that's where you stand the best chance in litigation of striking down these mandatory vaccination policies.
Let me ask you a question. You mentioned the daily testing. I've seen some information that would suggest that even the tests are very problematic from a health standpoint. What does someone say? Could there potentially be the ability to articulate both medical exemption and or religious exemption for even that test swab that's undertaken that supposedly has some really questionable toxicity issues?
So that starts to play with fire, because you have to be able to demonstrate that there is a reasonable accommodation short of vaccination, short of daily testing or pre-shift testing, that certifies or gives comfort that there is no or at least a very limited risk of passing on COVID.
Well, what about this? What about assailing the very policy, and then how could it be placed in the employer's court to actually show that there is a correlation, there's this rational nexus between vaccination and the safety in the workplace?
Let me make this very clear for viewers, because we've gotten this question sometimes daily from folks. If you work for a private employer, the Constitution and Bill of Rights don't apply to you. The Bill of Rights restricts government. It does not restrict private business. And that's something that we hear all the time. Oh, my constitutional right is to, not get vaccinated. Not if you work for a private employer. The private employers under the law is free to put whatever job requirement they want. I mean, if they said you have to be able to dunk a basketball and you can't dunk a basketball because you're short, you can't sue to get a job.
Employers can in fact discriminate, and they do all the time. They do a ton of discrimination. You just can't discriminate.
Race, gender, disability, age, religion, the usual suspects for the protected classes. But we discriminate as employers all the time. It's called job requirements. If you're a typist, you maybe have to type X number of words per minute. If you're a baggage handler at the airport, you've got to be able to lift 50 plus pounds. It's a job requirement. If you can't do a job requirement, you can't do it. I mean, Major League Baseball, as a pitcher, you better be throwing 90 plus miles an hour. Well, I can't apply for a job because I only hit 88. I don't get to sue for that. And that's something that I think is lost. And, look, we can disagree with these policies on a philosophical and even on potentially, other grounds. But the law is allowing the mandatory vaccinations. And right now, the only real way out that has success is medical or religious. Okay, those are your only real solid winning avenues. Other ways to attack this are not going to be effective. I mean, you can't just say to Pfizer, hey, I disagree with you requiring your employees to be vaccinated. That's not going to work. They're a private company, they can do it.
So let's shift gears a little bit away from the at-will dynamic. And let's say that I have some sort of an employment contract, which sets forth essentially the terms of engagement. And now, I've been living within the constraints of this employment contract. And now all of a sudden they're saying, oh, as an additional requirement for you to work here, you have to get swabbed or jabbed. Does that element raise any additional defense for a potential employee plaintiff?
Yeah, it certainly might. And as you know, Jim, I mean, anytime you're dealing with a contract analysis, no two contracts are usually identical. I mean, different clauses can be put in, but you're going to have two kinds of employment contracts: at will or for a definite term, meaning a for cause situation. If it's an at will employment contract, the same analysis applies as if you had no contract at all. They can change the terms and conditions and job requirements as they see fit under management rights. The analysis gets very different, though, where you've got a for cause situation. But in my experience, most employment contracts that are for cause are going to say that compliance with the employer's policies is reason to terminate somebody if they deviate. So it gets into a really muddy gray area that at least a muddy gray area is better than cut and dry, you have no claim. So it might open the door a little.
What about people who are just thinking about, I'm just going to go ahead and quit? I mean, my sense of the situation is that's like the worst thing you can do.
That is the worst thing you can do. If you quit, you are making my life just that much more difficult, because one of the elements of any kind of a discrimination claim is that the employer took adverse employment action against you, meaning you got fired. If you quit, there's an extra layer of proof that's required to prove up what's called a constructive termination. That means that any reasonable person in your shoes also would have been compelled by the employer to resign. It's a high bar. The case law is not real employee friendly on this. A good example of where it does qualify is when the employer sits somebody down and says, hey, look, it's Friday afternoon. You're either going to get fired or you're going to resign. But either way, you're not coming to work on Monday. and the employee says, okay, well, I guess I'll resign then. That's a constructive termination to the T. But if you quit voluntarily, you're generally going to be out of luck.
What about a situation where they say, look, we're going to do this the easy way or the hard way? The easy way is you resign, and if you resign, you get your PTO, you get all these goodies. And if we have to terminate you, you get nothing. Mm-hmm. Mm-hmm. I see a lot of people that are facing that very Hobbesian decision.
Yeah, I mean, that's still going to be a constructive termination, because either way, Monday morning, you're not going to work. The problem is generally documenting that, because oftentimes employers have that discussion and never have it written down anywhere that discussion occurred. And by the time I bring the lawsuit, that employer has generally changed gears and said, we didn't force anybody to quit. They resigned. We missed them. And that adds a real layer of difficulty that probably doesn't need to be there. So make sure, if anybody is thinking of resigning, at least in the resignation letter, document that something that says, hey, I was sat down on Friday afternoon and given 2 options. I'm choosing option 2.
So that would be one thing, just so we can land this. I know you have to head off to a hearing, and I really appreciate you taking time today. If someone is in this place where they're having to make these difficult decisions, and they're wanting to document the dynamics of the situation appropriately, and tee up the best leverage points possible vis-a-vis the relationship with the employer, and either motivating the employer to do the right thing before they terminate, or setting up for litigation after the termination. At this day and age, if you don't get some counsel from a lawyer, it's probably unwise, because it's a very sophisticated and nuanced dynamic. You hate to sort of pitch for it, but whether or not no matter who you go see someone, right? I mean, isn't that the most rational thing someone could do at this point?
I would actually say just maybe just a little bit more. I wouldn't want my podiatrist doing my brain surgery. Nothing against podiatrists. I would go see them for feet. This is a very specialized area. You have to, get to an attorney who actually does this kind of law. I wouldn't want my real estate attorney trying to draft a request for reasonable accommodations under the Americans with Disabilities Act. It gets screwed up constantly. And then somebody comes to us and we are looking at just a mess. So here's some just closing thoughts on really where employees need to go. You want to make this look like you are the most reasonable person in the room. Okay, I had counseled somebody just last week on this very point. Said, do not get, or at least don't look, offended, angry, unreasonable, difficult to work with. Remember, you want this to look like you're trying to maintain your job. You just need a little tweak in how you do your job, because you want to stay there. If you look at this as a philosophical war with your employer and act accordingly, by the time this gets to United States District Court, you're going to look like a difficult problem employee, no matter how sincerely held and passionate your beliefs might be, and no matter how correct you believe them to be. The test is always one of practicality. Be the most reasonable person in the room. Act and demonstrate that you're willing to work with the employer towards a reasonable accommodation. The accommodation doesn't have to be the one that you're requesting. The employer can offer something different, but have the discussion. Show a willingness to go back and forth with the employer. It's crucial, because the test is, can you perform the essential functions of your job with or without a reasonable accommodation? That is the legal standard, reasonable accommodation. If you are making an unreasonable request and not willing to be a little bit flexible, you don't stand nearly as good a chance in federal court.
And will you state that standard one more time? The audio broke up, and I don't know, it may just have been in mine, but if you could state that one more time, even if the audio hadn't broken up, it's a very good articulation of the standard.
So whether you have a religious reason or a medical reason for not being vaccinated, the test after that step is whether or not there is a reasonable accommodation that allows you to perform the essential functions of your job. The test here is reasonable accommodation. It can't be anything out of left field. It can't be something terribly onerous on the employer. Okay, I mean, if you ask your employer, well, that's fine, just build me a private office building somewhere else, or lease me office space somewhere where I don't need to be vaccinated. That's not going to be reasonable, because that's going to be an undue burden on the employer. Reasonable is the key. And remember, when we're dealing with vaccination policies, they're there to ensure workplace and customer-facing, position safety. That's what it is. So if you can demonstrate that your accommodation you're requesting can still accomplish the goal of reducing the transmission of COVID, you actually stand an excellent chance if it gets into litigation where you can win. But just simply saying, I'm refusing and I'm not willing to be flexible at all, sadly, the law is not going to help you. You're going to likely lose.
And further, the employee is not in a position to assail the rightfulness or the accuracy of the policy. The policy is almost presumed to be accurate and effective. So,
yeah. Just give you a good example of that, Jim. I mean, you could have a general, receptionist, office clerk who, the most weight they ever lift is like maybe a 5-pound file folder. But if the employer says that the part and essential function of that job has to be lifting 50 pounds, they got to be able to lift 50 pounds. I mean, the private employer
even if
gets
that,
to do it.
Well, the interesting thing is, the idea that taking a COVID vaccination results in safety, higher degree of safety to the customers, other employees, et cetera. If we just set that, no matter how esoteric or wrong, even if it's objectively, scientifically wrong, it doesn't matter. It's a policy of the employer, and they can hold that up, and you have to live within it.
You've got, right, your option at that point, if you don't philosophically agree with it, and if you don't have a medical or religious reason to not be vaccinated, your option is, as I say, it's like going to dinner at grandma's. Take it or leave it. Whatever she's cooking, you're either eating or you're not. If you have philosophical differences, I applaud you for, standing firm on it, but it comes at a cost, and you've got to be willing to pay that cost, which might be needing to find another job. Now, that said, there is no better job market to go find another job right now. I mean, you've got employers begging people to start work, especially unskilled labor right now. Holy moly. I saw a sign on a Taco Bell offering a $250 signing bonus to work at Taco Bell.
They have to pay me a lot more than that. Now,
you would need to pay me more than that too, but it's unbelievable, the labor shortage.
But the problem is, what about these nurses? I mean, now I have a ton of nurses. It seems like to me, and this is going to go down a rabbit trail, which we're not going to go down far down, but I think that there's going to be this whole new, birthing of industry for non-vaccine required, employers and businesses who don't buy into the whole vaccine thing. I think that's going to be a really hot place to build out a business.
You raise an interesting conundrum, and if you want to compare how two different hospital systems have reacted, we saw NCH very quickly have mandatory vaccinations for its employees, including nurses. Lee delayed and didn't do it for the longest time. Only now are they just going to require it. Why? We've got shortages, man. When you're looking at these stats about how many ICU beds are full and that percentage capacity, be critical in your thinking and analysis and look at whether or not that is capacity of staffed beds, as opposed to just how many beds there are. Very many folks in healthcare have told me, there's empty beds all over the place. There isn't staffing. And so you've got to question, if you're a COVID patient or you've got a loved one, that's hospitalized or needs to be hospitalized, are these mandatory vaccination policies actually wise in the face of a staffing shortage? When for a year plus, these nurses did not obviously have access to any kind of, COVID vaccine, yet they were, wearing their N95s, masking up, gowning up, and they were able to perform all of the essential functions of their job. So it does raise some interesting kind of questions there. And it also raises other questions. If somebody needs to get into an ICU and that hospital is below minimum staffing, does the hospital system face some liability here? That's a question for a different day. But it would seem to me that some of these healthcare systems are playing with fire. And right now, I'm not sure that they're being real upfront with the public about the ICU and ED staffing. That maybe these mandatory vaccination policies are actually going to result in a further reduction of available beds. That gets out. I'm not sure that the public, even the pro-vaccination public, is going to really get behind that. Because remember, when you go to the ICU, it's not a COVID ICU. This is a loved one who's had a heart attack, stroke, car accident, anything. And there aren't beds there because of a vaccination policy. I take no position on it, but I would be concerned if beds were not available for the general public.
And I really appreciated this conversation. It's just been a real blessing to have you on here.
My pleasure, Jim.
I hope that we can do this periodically.
Certainly, happy to answer those kind of general questions that pop up. This is just such a specialized area of the law. It's not anything that is simple. I think we can all understand a breach of a contract. You should have paid me X that you didn't pay me. Boy, is this very complicated, and it hasn't helped, quite frankly, that for the longest time the Department of Labor was changing their position seemingly by the day at one point. Where advice I was giving on a Monday gets changed by a Wednesday. So these are crazy times to say the least, and certainly those of us that are labor and employment experts are having to keep up very, very quickly. But the rules, are generally still going to be the same as I've laid out. If you can't demonstrate a reasonable accommodation that lets you continue to do your job, you're generally going to be out of luck, no matter if you have a medical or religious reason for not being vaccinated. You got to show a reasonable accommodation.
All right, Ben, thank you so much. And maybe we can chat again in the future.
Absolutely. Thanks for having me, Jim.
Thank you.